Whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Drew Corbin, and I'm here on behalf of the appellant, Drew Corbin, who also happens to be my mother. This is a simple case. This is a landlord-tenant dispute. The fact of the matter is there's a signed, handwritten agreement between the parties that they've been performing on for the last 5 years. For the last 5 years, every month, my mother has gone to the landlord's lanai and dropped off either a check or cash payment to secure her use of the property on 34404 Lock Road, Charbon Springs, Florida, for a horse stables. She trains and takes care of horses, and she's done it for the last 14 years. She staked her entire business on the performance and execution.
Before you go into too much detail about that, I don't think anyone's disputing she sounds like a lovely tenant. Took care of animals, horses, and did a great job. But you have a 50-year lease that you're seeking to enforce. I haven't seen a 50-year lease since World War II. Number one. Number two, there was a 90-day escape clause. Either side can get out of that 50-year lease by giving 90 days notice. So the judge found in favor of your landlord. The judge said, hey, I don't think the lease is dollar on space, which is the opposite position from what you're taking. But if it wasn't, I find there was sufficient notice. Is that correct?
That's not correct, Your Honor.
I mean, that was in a judgment.
It wasn't a judgment, Your Honor.
That's all my question. Was it correctly, what I said, was that in the judgment, whether you agree or disagree with the judgment? That was in the judgment.
Yes, it was, Your Honor.
Okay, your turn.
To address those points, Your Honor, with respect to the 50-year term of the lease, it could be a 100-year term, it could be a 200-year term. It doesn't matter. The fact of the matter is they performed on the agreement. The complaint from the landlord alleged one thing, that the signed handwritten agreement was not valid pursuant to the statute of frauds. The statute of frauds is a relatively new legal doctrine, and all it is a doctrine designed to eliminate fraud. That's it. That's the only thing it does. The only thing it does is to eliminate documents that are literally fabricated. They're literally not what they purport to be. So the moment the landlord filed a complaint and alleged that this signed handwritten lease agreement that they've been performing on for the last 5 years was invalid pursuant to the statute of frauds, they themselves have committed fraud. Because they're saying to the court, this agreement that we agreed to, we were offered, we accepted, we've been...
Your religion is partial performance, and that should take out of the statute of frauds anyway.
Immediately, because if we don't do that, then we live in a world where anybody can just go and make offers, start performing on them, and then go to court and say, oh, there weren't two witnesses. We don't need witnesses. The parties have witnessed the agreement themselves. It's self-authenticating.
Who prepared the lease? Buyer or lessee or the lessor?
The release was prepared by the tenant, my mother, but the fact remains that the lease was dropped off at the landlord's house, where it was likely considered for a number of days, and then both parties met in the landlord's lanai, reviewed the document together, and made changes to the document together, and then signed it. So to the extent that the landlord wants to say this phrase, 90-day notice, any changes, should be read to allow the agreement to be terminated, there's a couple issues with that. The one is her own deposition testimony, where she admits we never operated according to a 90-day notice provision, 90-day change provision. The second is the language of the document itself. Right before 90-day notice any changes, it says the term, 50 years. So the fact that it then says 90-day notice any changes, it must be read to not be in conflict with that previous term. And we can read it so that it's not in conflict with the previous term. We just read it to say that it's with respect to the preceding terms. There's no punctuation after it, and it only applies to those terms. If we read it to say that, we can...
Now, your client voluntarily left the property after the writ of possession was issued. She's not there now, correct?
That's correct, but my client did not leave the property until after the writ of possession was issued.
And you had a problem with the writ of possession because the clerk didn't issue it. The judge apparently did it by judgment.
Yes, the judge issued it.
There's no rule saying the clerk. The judge can do it, the rule says the clerk is the one who should do it.
I'm not aware of that, Your Honor.
Well, I guess I'm trying to find out, I think the clerk should have just done the possession automatically, maybe it was done. I don't think it's part of the record, but the judgment seems to award possession, and the judge didn't worry about the clerk doing it or not doing it. Does that pose a problem for you?
I hope it does, Your Honor. I was not aware of that specific issue. I hope it does, but I'm not aware of
That might be a little bit higher.
I'm not aware of that specific issue. I do know that
I thought that was part of the issue you guys were arguing over. If you're not, just keep going.
Nope, I look at this case very simply and I say there's a signed handwritten agreement that's been performed on for the last 5 years. The only allegation in the landlord's complaint is that the agreement is invalid pursuant to the statute of frauds.
So under your reading, what does the 90 days, any changes, what does it, ma'am, please don't make hand gestures, thank you. What does the 90 days, any changes mean?
To me, it's very clear what it means. It means that there were 90 days to make any changes to the terms that precede the phrase. And we know that's true by the landlord's own deposition testimony where she says, we didn't make any changes within 90 days. So she's admitting that's the right that we had. And then we look at her actions. She didn't give 90 days notice.
But I thought the leasehold term actually preceded the any changes 90 days. So by that argument, that means that the 90 days, any changes could potentially terminate the 50-year lease, which isn't unreasonable because, as Judge Valenti pointed out, 50-year commercial leasehold is uncommonly long. But it's almost a fee.
But let me take the flip side of that. So we got to look at it from the tenant's perspective. Is the tenant going to agree to this lease where she's trying to secure a long-term arrangement on this property because she's got senior horses that are at risk of losing their lives if literally they're just moved from the property because they're 30 years old, which is old for a horse. She's trying to secure a long-term arrangement. She's not going to agree to something that allows her to be terminated in 90 days. And the landlord didn't even have the authority to act upon that provision because the landlord didn't approach the trial court on a basis of breach. The landlord didn't allege that they had the right to change the agreement within 90 days. The landlord approached the court and said, here's this signed handwritten agreement that I've been performing on for the last 5 years. It's invalid because it's not evidenced by 2 witnesses. And the moment the landlord did that, they committed fraud. So as far as the 90-day notice changes, it can't mean what the landlord now wants it to mean.
Okay, well then help me out. What does it mean? Because it was a negotiated term, it got written in there. So what is it? 90 days any changes to the monthly rent? That doesn't seem likely. 90 days changes to the scope of the number of stalls? That doesn't seem, so what does it mean?
What it means, Your Honor, is that each party had 90 days to make any changes to the terms that precede the phrase, that follow the phrase. And the reason why they did that is because...
So in theory, let's say it's not a termination, in theory, by your reading of that argument, you're saying within 90 days notice we want to change this from a 50-year lease to a 1-year lease.
Only within the 90 days from the time that they signed the agreement.
See, now you're adding more on to...
That's the reason why that is it's very clear from the document and then very clear from the facts of the case. The parties didn't know all of the terms that were...
I mean, help me out here on that, because then what you're saying is, okay, we're agreeing to everything, but within 90 days we can change anything, which sounds like what you got is basically an agreement to agree. I mean, you don't have to finalize the contract. Any second is 90 days notice, we can change anything in the preceding agreement, anything, on 90 days notice. You don't really have a contract.
Well, you do, because when a party goes to another party and says, here's a lease to lease my property for 50 years, you can make changes to this document within 90 days, and then that 90 days passes without there being any changes, it's set in stone. And the reason the parties did that is because they wanted flexibility. They didn't know all of the things that were going to come up in their lease agreement. So they put this phrase in there as a way of giving them a window of time, and we know that's what it means, and we cannot allow the landlord to prevail on a theory that was not alleged in their complaint and that they actually did not obtain the legal authority to act upon it. What I mean by that is simply 90 days notice was never given. So how could they argue that we have the right to terminate this lease upon 90 days notice when they never actually gave 90 days notice to the tenant. The landlord wants to say, oh, they really had 90 days notice because 90 days have passed since the letter was given. Well, the letter was only a 30 days notice, and you certainly didn't wait 90 days till filing a lawsuit to get us off the property. So I think when the trial court looks at that evidence, they have to draw the conclusion that this phrase doesn't provide a notice of termination, right? Not when there's a clear terms.
Well, let's go back to basics. Who was leasing the property? Was the husband supposed to be on the lease, the lessee's husband? Because the trial court said he didn't sign it, so it wasn't enforceable.
Yes, Your Honor, that was another issue that the trial court had with the lease, is that the landlord's husband was not a signatory to the lease, and he also owns the property. But it was error for the court to do that analysis because they're only looking at the landlord's consent or agreement to the lease from a
But
subject.
my question is, was Gene McDaniel's name on the property, on the paperwork where he should have signed it, where his name was printed? The trial court said there wasn't witnesses, that would prevent recording, obviously, but was Gene McDaniel's name typed anywhere on the lease?
No, it was not, Your Honor, but
They expected him to sign
they didn't expect him to sign it. But when we consider whether an agreement was agreed to, we look at it in objective standard from the other party's position. And from the tenant's position, my mother, there was no way a reasonable person in her position would construe the landlord's actions and the actions of her husband as anything other than full assent to the terms of the deal. And the reason that is because the wife signed it in the lanai of the house where they both reside, and then the landlord and her husband performed on it for the next 5 years. So the landlord and her husband are out on the property, allowing the tenant to live there.
it. What about the lessee? Why is the husband out there also?
He lives on the property, he lives there just as much as the landlord, and he's out there performing on the lease just as much as the landlord is because he's accepting rental payments.
Two people leasing, two people signing the lease.
One person leasing, the tenant, my mother, two landlords alleged, but really both are performing on the agreement. So to the extent the landlord wants to allege this is an invalid agreement
How
because
many people sign the lease? Let's just break.
one,
One
two
person,
people signed the lease, but one landlord.
one landlord, one landlady. And how many people own the property?
Two.
Two people own the property and one person signs the lease.
That's correct.
And that's why the judge said it's not a binding lease. You don't have both owners.
That's correct, Your Honor. But
And I'm just saying, so that's what it looks like on that issue.
right, we find error with that, and the reason why is because the husband's consent to the lease is not a requirement for him to be a party to the lease. What's required is that he objectively perform on the lease,
Well,
and that's what he did. He accepted rental payments for the last 5 years. He allowed the tenant to go out onto the property. He never objected.
do you account for reformation to say only one person needs to sign this? I mean, if someone's leasing my property, I need to sign it, I've got something to say about that.
Right, and if your spouse leased your property to somebody else and that somebody kept going onto your property for 5 years, that somebody would be reasonable to expect that you were also agreeing to that, to agreeing to what your spouse had signed.
You're talking legalese now, or you're talking reality? Because reality, you're right. Reality is, hey, you didn't sign it too bad, but now there's a problem.
Well, I think the legalese matches the reality because the legalese requires there to be objective performance. Again, the husband, Gene, could have not known about the lease agreement at all. He could have subjectively been, totally against it with his wife and said, why are we still doing this? Why are we still doing this? It doesn't matter because objectively he's performing on the agreement. Objectively, he's accepting rental payments from the tenant.
Okay, you keep talking about objectively, tie that to a defense or a legal claim that you asserted.
So,
Was there, Judge Linton mentioned reformation, was there an estoppel claim, was there an estoppel defense, was there implied contract that it should be implied that he's a party to this contract, such as your story?
our defense and our answer was that the agreement had been partially performed, and that was all that we would have been required to allege based on the allegations in the complaint, because the only thing the complaint alleged was, here's this handwritten agreement that we've been performing on, and it's not valid pursuant to the statute of frauds. So we say, well, yes, it is, we've been performing on it. And then they go and say, oh, well, actually, my husband didn't consent, actually, we have a 90-day notice termination provision. As soon as the landlord says this agreement is invalid because my husband doesn't consent, she's basically admitting that she's committed fraud on her husband for the last 5 years.
You've said that like 3 or 4 times and mentioned numerous times in the brief, I get it, I'm really trying to focus this on tying this to the actual claim that was asserted by either party, and that was adjudicated by the court.
Right, okay, so let me take that. So to that point, I mean, we're not going to make any claim in our answer with respect to the idea that Gene, the husband, is not performing on the agreement because it wasn't alleged in the complaint. But as soon as it's alleged, it's a very simple legal argument to say, of course he's a party to the agreement, he's been performing on it for the last 5 years. It doesn't matter that he didn't sign the agreement. The fact of the matter is, he's accepted lease payments for the last 5 years, he's allowed the tenant to be on the property for the last 5 years. No reasonable person in the tenant's position could construe that. What's the...
But they didn't tie that to a legal theory, though. I mean, I hear what you're saying, you're making the arguments really well, but tie that to what legal theory is that tied to that binds a non-signatory to a lease agreement, a contract? What binds that non-signatory to? What legal claim? What ship are you sailing?
Yeah, it's part performance. That's what it is. She's the husband, the landlord has.
So it's an implied contract. Is that what it is? Because part performance only matters in a contract theory claim.
I don't think it's implied. I think it's the very agreement that's at issue in this dispute. Again, the tenant knows that the landlord signed this agreement. The tenant knows that the landlord's husband is performing on the agreement. So the landlord.
Let me make this easier, okay? Because I'm not doing a good job conveying what my concern is. My concern is, let me give you a hypo. All right, my wife enters into an agreement of some sort where she agrees to provide website hosting services or website design services, and she's performing on that agreement in my house, and she does it for years for a client. Client's not happy, the client sues her, and the argument is made is, hey, Matt Lucas he's aware of that agreement, he's a signatory to that as well, she's been performing all the time in his house, in the house that they share. How am I now a signatory to that contract? That's the concern that I have.
You're not a signatory, but you've performed on the agreement objectively, and so you.
So you would say I would be liable on that?
I think you would, because you're indicating to the other party that you are performing on it, and no reasonable person in that position would construe your actions.
I'm doing nothing but sharing my house with my wife in this scenario.
Right, as when your wife is also a signatory to the agreement. And look, the facts are.
Sorry, I just want to let you know you're at the 5 minute.
Okay.
Use your time however.
Thank you. If I may, could I reserve 3 minutes for rebuttal, and I'll just.
Yeah.
So, look, to your point, those facts are even worse here, and here's why. Because the landlord's husband has been performing on it from even before when they signed. The facts establish that the landlord's husband was out with the tenant and the landlord reviewing the property, okay, with the tenant's clients. So the tenant's out there with her clients, with the landlord and the landlord's husband, looking at the property to determine its viability for whether she can operate her business on it. How is a reasonable person in her position supposed to think that he's not agreeing to this agreement when his wife goes and signs the agreement in their house and then performs on it for the next 5 years? He would have had to immediately, almost immediately, gone to the tenant and said, I don't agree with this. I don't know what you signed. I don't know why you're here, but I don't agree with this. If he doesn't do that, if he's silent, then he starts to indicate to the tenant, I'm agreeing to this objectively. No reasonable person could think otherwise, because you have a husband and a wife that are performing on an agreement. The wife signs it. The husband was there before the negotiations. He's there after.
Attorney, what are you saying? She didn't have a power of attorney to sign for his behalf. His name is not on the list.
Maybe all he was agreeing to was just a month-to-month kind of deal, like, let's see how it works. Maybe that's all he's agreeing to.
But that's not the law, Your Honor. It doesn't matter what he was subject.
This is the one-page lease.
That's right.
This is ripped out of a notebook. It's a holographic lease. I haven't seen anything that crazy looking in the law, not to be deferential, but usually on a 40-page lease for a thing that long. And usually 5 or 10 year increments. You just don't have a 50-year lease and claim that's valid and enforceable. So I can understand where the judge was coming from. Judge probably never saw one like that either.
Courts have upheld oral agreements under similar circumstances, not just written agreements. It's not the vehicle by which the agreement is conveyed, it's whether the parties actually agree to it, and there's no way. Of course there is.
Walking up the property doesn't mean I sub the lease, and I understand it thoroughly. There's no ambiguities, and I agree to everything in there.
right? So maybe there's not evidence that he subjectively agreed to it in his mind, but that's not the law. The law is whether a reasonable person in the tenant's shoes would construe his actions
So
as.
you had an actual trial, and the judge said there's no valid lease and other things.
Well, we're here,
I'm not sure what the argument is that the judge got it wrong.
the judge got it wrong, Your Honor. We're here on competing motions for summary judgment. The judge is saying this lease agreement isn't valid because the landlord's husband didn't consent. That's not even the law, whether the landlord's husband consented to it. The law is whether his actions would indicate to a reasonable person in the tenant's position that he was agreeing. And again, when we look at, he's there looking at the property with the tenant, he's there allowing the tenant onto his property for
So
5 years.
under your theory, no one has to ever sign a lease, they can just occupy it and say, we have an agreement verbally, and it's binding, and we've partly performed it and paid for 5 years.
I think it's a factual scenario, right? It's dependent on the facts. But as time starts to go on, maybe instantly, because there were case law that was cited where, hey, my husband didn't agree to this, my wife didn't agree to this, she wasn't in the room. All of those cases were challenged instantly, within a matter of weeks that they didn't agree to it. Here, this is different. We have the husband saying, I didn't consent to this 5 years later. So we have 5 years of objective performance on the signed and written lease agreement, including him accepting the rental payments for 5 years. And then,
Sorry, you need to wrap up. You're at the end of your 20 minutes.
if I could just make one more point.
No, you need to wrap up.
Okay.
You've had 20 minutes.
Thank you.
All right, sir.
Good morning, and may it please the court. My name is Avery Chapman. Fun fact, I'm founder of the Florida Bar's Equine Law Committee. I'm glad to hear the word horse in another case. We're always happy when horses intersect with the law. I think what Judge Valente was getting at was honing down on the Murray v. Sullivan case, which was cited at record 99 in the motion for summary judgment, and I think was part of what the judge relied on. I know we're here on Mr. Corbin for his client appealing the writ of possession, but it seems that the writ of possession was based upon the findings under the MSJ. Under the Murray v. Sullivan case, the idea was, well, before you can have an exception for a missing tenant by the entirety, for a lease, let's say, or encumbrance of a property held by a husband and wife, you have to have clear and convincing evidence that the transfer does not, one, adversely affect the interest of the other spouse, and two, is done with the full knowledge and assent and acquiescence of such spouse. That's, I think, what's behind the questions, and that's a question of pragmatics here. And I know the court has been concerned with that. Our response to that, which is reflected in the record, is Gene McDaniel testified unrebutted that his wife didn't tell him about a written lease of 50 years or of any term. He assumed that Miss Corbin was there under a month-to-month, terminable at any time type of tenancy. He
Is that in
didn't.
the record, did that come out in the summary judgment, or how do we know that?
You will see that in the record that's filed with the court, but it came out in numerous places. I can actually give you the record pin sites if you'd like. You tell me. I'm happy to pull them out.
Everything they have is this thing.
Yeah. Okay. Let me do that for you. Gene testified, and if you look at record 99, it's set forth in the brief, which kind of gives you the pin sites to the depositions. But Gene testified throughout his deposition, pages 69, 82, 83, 83, 84.
Is this on the record or the deposition?
I'm going to get you the corresponding one right now. Here we are. I'll get it to you in just a second because I don't want to waste some time. It's all part of the record there that Jean testified and Diane testified as well in her deposition, also part of the record, that she never told anybody, she had forgotten about the written lease, she didn't tell Jean, and that Trudy Corbin took the lease with her once it was signed and never received a copy. So she didn't even think about it. So what does that leave you with? I'll get to those citations just a second. That leaves you with a gentleman who's a tenant by the entirety. Ms. Corbin testified she knew they were married when the property was purchased, who did not know of some 50-year lease, basically a fee type arrangement, would never have consented to it. It was also testified in the record that they were in their 50s. A 50-year lease would have been lifetime for them and would have for their children for whom they purchased the property, also part of the record testimony, would have put the children subject to Ms. Corbin's lease until the children were in their 60s. So Jean testified, I never would have agreed to such a lease, and of course I didn't. I understood she was there. So that's what the Murray v. Sullivan and its progeny in those cases are, I think, where the judge was getting to when he asked that question.
What about Mr. Corbin's argument that, hey, that may very well be, but that's not the flag you flew on your pleading? I don't know if there's a pleading objection made to the motion for summary judgment. It's
Sure.
kind of over that a lot.
First of all, Mr. Corbin, that very argument, I'll address it and I'll answer it. But Mr. Corbin himself did not raise that argument on appeal. Okay. But to answer your question, the judge, and again, this is a little tricky because there's a motion for summary judgment ruling, and then there's a writ. In the motion for summary judgment ruling, about a month prior to the writ, maybe a little more, the judge said, look, I find several things. I find one, the lease was invalid because it missed the two subscribing witnesses, which was required under the 2018 version of the statute, and because Jean's signature is missing. Then I also find...
Okay, that's the
Right.
order. I'm asking about the pleading.
Right.
Pleading
Right.
precedes the motion and the order.
So-
What was the pleading?
So we pleaded, at the time, we pleaded the missing two subscribing witnesses. Okay? What was essentially tried by consent through the motions for summary judgment was the issue, because this thing was scheduled for trial the next week.
Yeah.
But what was tried by consent through the motions for summary judgment and was fully briefed by both sides was the issue of
Lack of a subscriber.
Lack of-
Lack of a co-owner.
co-owner. Okay, that was briefed both ways. There were
On the
motions.
motion.
Yeah, motions and cross motions. So it was essentially tried by consent would be my argument. And briefed by consent and addressed, and Mr. Corbin had the opportunity to rebut that, however he did, and he did file a reply brief to our cross motion. So he had the opportunity and engaged in that. So that's my response to that. I'm pleased to answer any other questions. Of course, I had a full set argument, but I'm sensing from the court's inquiries that you had specific points. If not, I can certainly, in the time I have, dive into that. You tell me, and I'll proceed either way.
Any questions?
No questions here. Thank you.
Okay, so I'm just going to make pinpoint a couple points real briefly then, if there weren't any specific questions. Again, I think it's important to understand that this was sort of like a decision tree type of result. It was, okay, again, let's look at the face of the handwritten lease prepared by the lessee. The judge found, under summary judgment, that there were some issues with it, well, I'm saying technically or statutorily. Missing subscribing witnesses under the 2018 statute, missing Jean Daniel, the tenancy by the entirety signature. But if, and it says alternatively, or alternately, in the MSJ order, if it's valid, it still is terminable upon 90 days. I apply the plain meaning of the statute, plain meaning of the language there. 90 days does not mean something like 90 days only to terminate. It doesn't mean anything like that. It's very clear. It's a 90-day notice, any changes. Change can be termination. Judge Lucas raised the point that could have changed the contract to be a one-year term. By the way, you raised something about agreement to agree. I actually briefed that in our appeal brief response. That was an issue of an illusory contract. That if you could change if you could change anything in a contract, then basically you have and I will if I want to argument, which is another way illusory contracts have been phrased. And our position was, well, then alternately the contract was a illusory contract, even if the court didn't find. So that was how we got to where we were. The writ of possession, emergency writ, was issued after Diane Corbin put in an affidavit at record, it's either 1095 or 1118, where she said, look, there's fires going on, there's people there without liability waivers, there's business being conducted, there's all sorts of things that aren't good there happening, this is dangerous. So the judge had her own reasons to issue the writ, independent of finding the lease to be invalid. So I think that's important to note. At this point, from a pragmatic standpoint, we had a lease. The theories were tested by Mr. Corbin. They were fully heard by the judge. They were fully briefed. Any issue that wasn't raised in the pleading was then tried by consent. 1 second, please. Thank you. I have nothing further. If the court has any questions.
All right, that concludes our docket for today.
Did I have any minutes?
You used your 20 minutes, I'm sorry, sir.
Thank you.
I tried to let you know. All right, thank you both.